From Studio 69, this is CVM Live, the evening edition.
Good evening, it's Saturday, September 3. Welcome to CVM Live, the weekend edition. I'm Adrian Atkinson. Coming up in the first half hour of our 90-minute news program, CVM Live Extra, an in-depth look at selected top stories of the news week. Coming up at 8, major stories, regional and international news. There's E-Live, Inspired Jamaica, Sports Live, and the weather. So stay with us. The rights of Jamaican migrant workers, that was the topic for discussion earlier this week, following claims that in some places their treatment is akin to systemic slavery. To explore the issues, we were joined by Canadian immigration lawyer Makeda Bramwell of Coradec Law and Andrew Morrison Mighty, head of the Civil Litigation Department at the Kingston, Jamaica law firm TWP Attorneys, as well as being an attorney with the Toronto law firm Morrison Mighty Law.
The terminology of systemic slavery, an exaggeration based on your knowledge and information, an exaggeration or closer to the reality of the Jamaican worker in Canada?
Absolutely. There have been a number of reports, documented reports over the years that speaks to the number of issues that migrant workers, particularly those under the seasonal agriculture worker program, that they face. And these issues ranges from racism, housing conditions, a number of issues. So it is, I would say yes.
And Andrew, if you could chime in, are these concerns new? That is gaining steam, as we mentioned, in the international press, and it's a talking point here in Jamaica. But are these new concerns?
Not at all. In our preparation for this little segment, we did some research. And of note, for instance, Mexico's Consul General in Vancouver called out the Canadian provincial and federal governments for, I quote, the lack of oversight over the deplorable working and living conditions on farms. The Consul General highlighted issues such as housing facilities without mattresses, covered in trash, and infested with cockroaches. And these observations were made based on a visit to the farms and conversations with thousands of migrant workers over several years. This was reported in an article penned by Stefan Labey titled "Conditions Are Deplorable. Mexican Diplomat Calls for Oversight for British Columbia Migrant Workers." That was reported in Tri-City News, 27th June 2020.
And let me just add to what my colleague said. This farm in British Columbia not only, has Mexican workers, it also has Jamaican workers. So if one government can call out the deplorable condition that our migrant worker faces, then certainly there are concerns there, which I believe the Jamaican government should do an internal investigation.
Let's talk about the contractual obligation of the employer to these migrant workers. What's their responsibility?
Well, certainly we have to look, when we talk about the contractual obligation, we have to look at the protection, the legislative protections that are in Canada for these workers. And certainly, just having looked at the Employment Standard Act in Canada, the migrant workers, because of the type of program that they're under, they are exempted under Section 17 of many of the clauses. So what I am saying is that there are a number of protections for other workers in Canada, Canadian residents as well as permanent residents, but migrant workers are exempted from simple things like overtime hours, vacation pay, breaks. They are exempted under this clause because of the type of program.
What then is the redress? What's the recourse for migrant workers if their rights are violated in any way as it relates to the employment relationship?
Yes, in terms to answer your question directly, there are three major statutory provisions or statutes that apply to the migrant worker context: the Workplace Safety and Insurance Act, the Occupational Health and Safety Act, and the Employment Standards Act. But it's one thing to have rights on paper, but it's another thing in terms of the enforceability thereof and what these rights mean in actuality. It has been found, on account of looking at a number of cases that have gone before the courts, that particularly in the context of the Ontario Human Rights Code, there has been a narrow interpretation thereof in terms of the rights of migrant workers. And I want to point to two cases that illustrate the situation. Pearton, Ontario Community Safety and Correctional Services was a case involving a Jamaican worker under the SOP program who died while working at a tobacco farm after a 1,000-pound tobacco bin toppled onto him. Despite advocacy for an investigation into his death, an inquest was denied. An application was brought before the Human Rights Tribunal of Ontario, where the applicants argued that Section 10.5 of the Coroner's Act discriminated against the worker on the basis of race, ethnic origin, and citizenship, contrary to the Human Rights Code. The provisions of the Act required mandatory inquests into the deaths of workers in the construction and mining industries, but not in the agricultural industry. The tribunal did recognize the racialization and vulnerability of agricultural workers, but found that the provision of the Coroner's Act had a disproportionate impact on this group, but ruled that this impact did not create a disadvantage by perpetuating prejudice or stereotype or result in substantive inequality for the workers when considering the context and purpose of the provision. This decision has been highlighted by many jurists and commentators as demonstrating the difficulty in ensuring employer accountability for the risk that the SOP worker faces due to their working conditions. So it's one thing that there are statutory provisions that on paper would seek to regulate the context or the circumstances that the worker works in. But it's another thing because of the unequal bargaining power, creating a situation where workers are often disinclined to complain against their employer in the first place. And another case that I wanted to bring to your attention is the case of Louis Gabriel Flores, which was a case before the Labor Relations Board of Ontario. This migrant worker, Louis Flores, Mexican, was dismissed by his employer after speaking to the media about his health and safety concerns during the COVID era. He was a worker entitled to protection under Section 50, subsection 1 of the OHSA, Ontario Health and Safety Act. This provision prohibits employers from making reprisals, including in the form of discipline, intimidation, or threats, because the worker has acted in compliance with this act. As a result of complaining, the employer booked and paid for Mr. Flores to fly back to Mexico the very night news came of his complaint. Assuming that he had been dismissed, Flores spoke to a university professor he had been in contact with about what happened. She arranged for him to be picked up from the farm. After a few months, the employer made an offer for him to return to work. He refused due to the poor working conditions. The Ontario Labor Relations Board found that he had been dismissed because of his efforts to seek enforcement of the Ontario Health and Safety Act, contrary to Section 51, subsection 1 of the Act. The finding of dismissal was based on the former owner's confrontation of Mr. Flores in his bunkhouse when he was told he would be sent back to Mexico, and the fact that the employer paid for his flight home. The board awarded Flores over $20,000 in damages, including damages for lost wages, loss of future earnings, loss of reasonable expectation of continued employment, and for pain and suffering. In its reasons, the board noted the power imbalance between the employer and Mr. Flores as a migrant worker who did not speak English and relied on the employer for wages, shelter, and transportation. This case has been commented on by many jurists as a rare instance, in that it is rare for a seasonal migrant worker to have their case heard by a labor board. While it was a win for Mr. Flores, it is more representative of the prevalence of unsafe working conditions and reprisals faced by migrant workers than their ability to seek and obtain meaningful redress.
So if you could pause there just a second, Andrew. So the question then is, for our Jamaican workers, there are several making complaints now and hoping for some intervention. What's the solution then? Is it going to require some bilateral discussions between Jamaica and the Canadian government? Makeda, where do we start with the solution?
Certainly, and I just want to draw your attention to the fact that the SAW program, which is a seasonal worker program, seasonal agricultural worker program, is really not a treaty program. It's really an intergovernmental administrative arrangement between the two governments. And so for any type of changes, it requires changes from a policy level, a legislative level and a policy level. And so the government of Jamaica, it is their responsibility to have these kind of talks with the government of Canada for those changes to take place. Because these changes have to take place not only from a labor relations perspective, but it has to take place from an immigration perspective as well. Because when the migrant workers come to Canada, what we find is that they come under a closed work permit. And we have to talk about that. Because what they are subjected to is that the employer-specific work permit that they're on, when they're faced with these kinds of discrimination, they can't go to another farm and say, you know, I'm having difficulties at this farm, so therefore let me transfer. No, it is not like that. They can be immediately removed. In fact, there are policies that empowers the employer to immediately remove them and book them on a flight to Jamaica, which talks about the deportability of how easy it is for an employer in Canada to deport a worker when they make a complaint about discrimination, racism, housing conditions, any of this. So it has to come from the government of Jamaica. It has to come from the Jamaica Liaison Service, which is the organization that the Ministry of Labour places in Canada to protect these workers' rights. Those talks have to come from that level.
What then of the role of the Jamaican consulate or the High Commission in Canada? Do you find that our workers seem to, that is their first point of contact? What's the role of the consulate there in Canada?
Certainly they can play a role as well by, you know, investigating some of these complaints, by looking out and providing accessibility to services for some of these workers. And for those of the workers who are watching us, or families who are watching us today, speak to an attorney, speak to a lawyer who has knowledge and experience. In fact, call Cordec Law and speak to myself. But over the years, I've represented many farm workers who have gone through similar circumstances, issues of accessibility to Ontario OIT card. For example, they're not, you know, eligible for a OIT card until 3 months of being in Canada. So what that means is if they have been injured on the farm, they have to pay for healthcare services in most instances until they are able to access healthcare. So these are certain, and certainly Mr. Morris Might is a human rights lawyer who can certainly advance cases similar to what we have heard reported.
Andrew,
In my experience, in my previous employ as a prosecutor, I used to receive calls, particularly in the after the pandemic began about March 2020. Between 2020 and the beginning of this year, I received so many calls about workers and their plight, particularly on because.
We'll take a break on Live Extra. More when we come back.